hosting or really kind of you can think of me as a conversation guide for this particular session on virtual hearings. I'm joined today also by Joe Wheeler. Many of you will know Joe. He is with MTG Management Consultants, and also thanks to Joe's team, they're the sponsors of this particular session, and also with Alex McAdoo, who's with the IJIS Institute. And so before we kick off this particular session, I just want to give you a little bit of background on IJIS Exchange and this conversation that we are putting together today. If you're not familiar with the IJIS Institute, it's a longstanding believer in the need and benefit really of connecting justice agencies and those practitioners with industry technologists. And that really crosses all aspects of justice, like courts and corrections and prosecutors, defenders, the entire slew of that. And that cross-pollination and cross-agency collaboration is one of the things that really sets the IJIS Institute apart, and I think is a real value add about them. Now, of course, also along with organizations like the National Center for State Courts, IJIS and NCSC, as an example, have gotten together over the past several years and been sponsoring in-person summits that bring together practitioners and also industry technologists. And the whole point behind that is to have a dialogue, a real conversation between practitioners and the industry side that is really an open exchange where and it's really concentrating on brainstorming and and that exchange of ideas. So here we were faced with what we're going to talk about today, and that is really the pandemic and how we're all kind of figuring out ways around that and through it. And we didn't want to let another year pass without having a summit much like what we've had in the past to encourage that conversation between both sides of the practice, especially in terms of the courts. So this morning we took off flying at about 50,000 feet, and we were really looking at kind of a broad range of the procedural changes and things that have changed that have been ushered in by COVID. And especially those things that have forced the court's hand in terms of technology adoption. So we talked about things like text messaging and overall access to courts, even through just basic online information access. We talked about social justice and the need to become even more data-driven to make sure that the courts are, doing the right things to serve the most people in the best ways. We talked about plain language, and this session now is going to dive into one of those technologies, and that is remote hearings. Because as we all know, remote hearings is not new to the courts. That definitely has been going on prior to this pandemic. But now, the floodgate has really opened, and it has underscored the need for the court to be able to hold not only their hearings, but meetings and conferences and, all of those kinds of exchanges using some combination of remote or virtually delivered technologies. And so that means a host of considerations have really fallen on the courts, what platforms to use for what types of cases, under what circumstances, how they interact with parties and participants, to how they're getting the business done of the court while they're in those remote hearings, even to the extent of the debate around whether virtual hearings are more or less fair to those people who are participating in them. So we've brought together for this conversation a panel of very esteemed practitioners, and they'll each be talking for about 10 minutes about how the pandemic and has really kind of forced their hand, I guess, right, in terms of remote hearings and how they're handling those kinds of things. We have with us today the Chief Justice of the Michigan Supreme Court, Justice Bridget McCormick, who will be our keynote speaker. And we have Stacy Mars, who many of you may know. Stacy's had her hands in many aspects of the court system in the state of Alaska, and she's the court administrator for the Alaska court system. We have Judge Hale, who is with the district court in the city of Sherwood, Arkansas. Robert Adelardi, who is the CIO with the Florida Administrative Offices of the court in the 11th Judicial District. And then we have Heather Pettit, who's also a CIO, long-standing CIO, and she's with the California Judicial Council. And Heather will be talking more to the aspect of funding for these kinds of technologies. So we're excited to have you all here and to kick this off. Before we get started, I want to just make a couple of housekeeping comments. Everybody has been automatically muted, and we appreciate you staying that way until and unless you're speaking a little bit later in this session. We're going to kick off with this panel discussion. You should feel free to use the chat box to ask questions as our panelists are speaking, and then we'll get to that conversation once the panelists have concluded. You can also use the ability to raise your hand, which is over there in your participant box, if you will, the participant section, and we'll have you unmute yourselves and just have you engage right into the conversation if you're so inclined. So we're going to go ahead and get started. We're going to start with Chief Justice McCormick, and then we'll tee up each panelist separately, and then open it up to all of you to be part of the conversation. So Chief Justice McCormick joined the Michigan Supreme Court in January of 2013, and she became Chief Justice just about 2 years ago in January, I think, of 2019. Now, she also continues to teach at the University of Michigan Law School, where she was a law professor and dean before joining the court. As you can imagine, Chief Justice McCormick has a long list of accomplishments and awards. Many of those are really centered on, and they result from her very keen devotion to helping people access a fair and equitable justice system. And I think even more so, to help people come out of the system believing that they've received justice, whatever their dispute, whatever their outcome. As Chief Justice, she continues to step on the gas in that regard. She promotes a host of statewide initiatives that focus on those very same values and missions. For example, she has helped to launch the Elder Abuse Task Force, the Michigan Access for All Task Force. She's promoted online dispute resolution throughout the Michigan courts. She has organized one of the first expungement clinics in the state, and she's been super instrumental in Michigan's participation in the regional judicial opioid initiative as well. So I won't keep waxing on. Welcome, Chief Justice McCormick. We are delighted to have you as our keynote today. And one thing I guess I'll note and then just lob it over to you. One of the things that has been attributed to you is a comment that the pandemic was not the disruption we wanted, but was absolutely the disruption we needed. So perhaps you can take off on that and tell us a bit about your perspectives around.
Absolutely. Thank you so much for that very nice introduction, generous introduction. And it is an honor to be part of this particular convening for this particular discussion. I am very happy to be here and looking forward to the hearing from my co-panelists and the discussion. I have found myself to be somewhat of an evangelist for this moment, for the changes we are making. And maybe more so for the possibility of coming through this period with a more transparent, more efficient, and maybe most importantly, more accessible justice system, and all of the payoff that that will provide across our communities. We have seen more change in 7 months than in the last 7 decades. When you see photos of courtrooms from 1918, they look a lot like they looked in March 2020. There are not a lot of differences in those photos. And we have been uniquely successful at resisting change, and in particular, the tech revolution that's come for so many other industries. Some of that's cultural, some of it's normative, some of it's even legal, right? We are a profession built on a commitment to the past. That's a very important part of our value system. And it's allowed us to put blinders on and let every other industry be disrupted by technology in the last couple of decades, while we, forged ahead with notepads and pens and paper file folders. But then March 2020 happened, and this disruption that we needed unleashed our inner entrepreneurs, sometimes kicking and screaming, sometimes not. But not only were we forced to do everything we used to do differently, but we were also forced to approach it differently. And I mean by that, we were forced to think about what we were doing differently. We were able to try things quickly and fail at them. We were able to try things quickly and tweak them and make them better. My court issued 21 emergency administrative orders in, 8 weeks. We usually might do 2 a year, and we labor over every single word. We were spitting those things out like, I felt like Lucy and Ethel with like the cookies on the conveyor belt. And when we messed things up, we just fixed them. It was kind of exciting. Michigan was in a little bit of a unique place. Before COVID, we had actually already purchased Zoom licenses for nearly 600 judges throughout the state. Most people weren't using them, however. And we got them these Zoom licenses thinking Michigan is a big state. We should start figuring out how to do some things remotely. And most judges just thanked us and put them aside and never thought about them until March 2020. And then all of a sudden, with that hardware and software in place, we had also purchased the Polycom system, so they had the hardware and the software to move quickly. We were able to ramp up our virtual proceedings quite effectively, almost overnight. We expanded the Zoom licenses to magistrates and referees, so over 1,000 judicial officers had them. We issued a series of orders that removed every barrier to remote proceedings, so judges could even preside from their homes. Our JIS team, our Judicial Information Systems team, provided guidance to courts on how to use Zoom, how to avoid Zoom bombing, how to make sure that the public could see what was going on in their courtrooms. We chose the YouTube platform to stream to. And since the end of March, Michigan courts have held more than 1.5 million hours of remote proceedings. The public has used our virtual courtroom directory. We stood up a virtual courtroom directory that's it's a map of the state of Michigan. It has all 83 counties, and you can click on any county and see which judges are working in their Zoom courtrooms, and then you can click directly on their link and watch what's happening in their courtrooms. And people have used that directory more than 115,000 times. Local trial courts have nearly 50,000 subscribers to their YouTube channels. In one particular trial court hearing that was very high interest because it was about the governor's emergency orders, at one point there were 8,000 people tuned in to watch that hearing. Obviously, if that hearing were happening in a courtroom, the judge might have fit 50, I don't know. 8,000 people in the state were watching that hearing happen as it was happening. We stood up statewide online dispute resolution. So every single person in the state can use that platform. It's an asynchronous platform, and it is absolutely free. And we just unleashed people to try things that they otherwise never could have tried. So just let me give you just one example. Here in Washtenaw County, in Ann Arbor, where I happen to live, a local magistrate, together with a local police officer, the police officer travels to the homeless shelter and a particular park where a number of homeless people gather most days with his iPhone, and gives anybody with an outstanding warrant the opportunity to clear that warrant from the park or from the homeless shelter. The magistrate tunes in in the Zoom courtroom, and they give people the instructions they need for, to make sure the case is taken care of. And so she literally is bringing the court system to people where they are. It's awesome, right? And it wouldn't have happened without without this pandemic. The upsides that we've seen are enormous, some perfectly predictable. The efficiency for lawyers and litigants alike, the number of people who can watch hearings that are pretty interesting. Most people are not that interested in most of what we do. My court's been streaming our arguments for many, many years, and I sometimes think my dad is the only one watching. But sometimes people are interested, and now they can watch. And some of the upsides maybe should have been predictable. The higher rates that we're seeing of appearances by self-represented litigants is a wonderful benefit. People are, transportation can be tricky, childcare can be tricky. It's hard to take a day off from work, but if you can tune in on your phone, you can make your court appearance. And so that's an enormous benefit. Kids are far more comfortable talking to their phones than they are in a courtroom talking to a judge. Repeatedly, I hear from judges who have dockets with cases with kids involved in them who have said, for 9 months, I couldn't get a word out of this kid in the courtroom, but on her phone, she wants to show me her homework. She wants to show me her room. She wants to show me her dog. And I have a much better sense of what her life is like and what's happening in it. That's a wonderful benefit. And all of this is simply as a result of moving courts online. That's all we've done, really, right? We've just moved what we did in courtrooms onto this remote platform. We didn't have time to figure out all the other ways in which we could make this a better experience for lawyers and litigants and court staff. But we now know that we're capable. We know that we can do so much more, and that's exciting. Courts online are here to stay, but we have to move to online courts now, right? We're going from courts online to online courts. We're going to build what's actually helpful to all of the people who have to use our courts. And let's face it, before March 2020, we were not nailing every aspect of our justice system. The civil justice gap, we have just nibbled around the edges, but we have never been able to solve for that problem. 8 out of 10 people in Michigan and in most states with a civil legal problem can't afford lawyers. They either have to navigate courts on their own or they simply don't try. And simply don't try is usually the option they pick. And at the same time, we just happen to also be undergoing a massive in the most robust conversation about race and poverty in our criminal legal system that we have had in my entire career as a lawyer, which is now into its 3rd decade. And all of those things are happening at the same time. What an opportunity. What a wonderful opportunity. Let's use this disruption to build a justice system that grows confidence in the rule of law, that grows confidence in government, one that's more accessible, one that's more problem solving, one that connects people with resources, one that collects and publishes data, one that's more just. Everything is possible right now, and I think that's really exciting. So thank you for including me today. I'm really looking forward to hearing from the rest of the panel.
Well, thank you for those comments, Justice. I think it is exciting, right? The opportunity that even just this one aspect of courts online, brings to the people that the court system serves. Stacy Mars, this is something that you in the state of Alaska have really been, I think, dealing with over a long course of time, right? You have a lot of rural population. Making your court system super accessible is something that you've been working on for a long time. And so what do you want to talk about in terms of from a court administration perspective, and maybe even bringing in that aspect of really a more rural or what might be inaccessible justice, and making that more accessible. In court administration, you're often sort of directing all of those parts and pieces, right?
Yeah, absolutely. Well, thank you, Sue. My name is Stacy Mars, and I'm the administrative director for the Alaska court system. And everything that Justice McCormick said is 1,000% true, I think, for every court in the country. And it's really, the pandemic is really the best thing that ever happened to us, although it's incredibly tragic and stressful on so many levels. But the change that we needed to make was probably only possible with some kind of really disruptive event that we have no control over, like the pandemic. And much of the last 8 months, honestly, has felt like a crisis. And especially in the early months when everything was new and unclear and information was coming at us all the time, rapid fire, and you're really doing your best because you're not a public health specialist to try to discern what are we supposed to do. And again, unfortunately, it feels like that a lot every day now as our cases are surging to record levels, much, much higher than they ever were at the beginning of this pandemic. So I looked up the definition of crisis, and I found two definitions. Crisis is a time of intense difficulty, trouble, or danger, and it's also a time when difficult or important decisions must be made. And a lot of the first part of that definition is really dire, and it has pretty negative connotations, and that's absolutely true today. But the second part of the definition is the one that I really would rather focus on, and particularly a time when a difficult or important decisions must be made. I like the synonyms that are associated with this in the dictionary, which are turning point and crossroads. And I suggest that making decisions with a turning point approach in mind when dealing with this crisis in a way that implicates access to justice in the immediate, short, and long terms is really the way that I think collectively the justice system needs to embrace the changes that need to come from this pandemic. And we really can't ever let a crisis go to waste because it's really the mother of invention. And we've seen in other crisis times in American history where crises have really spurred invention, like World War II, you're probably familiar with, but was a time of staggering innovation that still is with us today when there was discoveries of radar and penicillin and pressurized parts of airplanes that we all enjoy today. Well, not currently, but and the list is quite long, but these emergencies really have to inspire creative thinking. And it's really amazing to see what has happened because the changes, like the justice said, have happened, things that nobody would ever think were going to happen, really happened on a dime. And as Sue mentioned, in Alaska, so because of our geography and we're hugely enormous, this state that I call my home, and also 90% of our communities are not connected on a road system. So that's created challenges for us way before this pandemic that frankly have benefited us during this pandemic because for decades we've done remote hearings. They're different than we are doing now and that most of the country is doing because most of our remote hearings have historically been done with the most simple piece of technology, which is a telephone. And even though I know this is a pretty tech savvy audience, I always want to remind folks that simple technology often might have a real key to answers. And so don't overlook simplicity because it's worked really, really well for us. Every one of our courtrooms has had an 800 number enabled with it for a really long time. So that's something that we didn't have to change, luckily. We've long been on digital recording and all of our courtrooms have sound systems. So that is some basic infrastructure that makes remote hearings easy for us. And it's very culturally appropriate in Alaska for people to be part of a remote hearing because it's just the way we do business. So we don't require people to get on airplanes to fly to their hearings generally. We have judges who appear by phone. We have lawyers that almost never physically go to court because some of our many communities have no lawyers present in them. So we are just super comfortable with remote operations. But when this pandemic hit and then we started to see all these pretty snazzy presentations about how Zoom was happening and you could do all these cool things, we thought, well, let's get on board there. So we have already been using Polycom for many years. So we did have video capabilities. We mostly use that in criminal matters between our jails and our courtrooms. But this pandemic really got us thinking that like we did not want to transport people from the jails to court and vice versa, and neither did the jails want to transport anybody. So video became a really important part. But while that said, it's also quite challenging. So while Justice McCormick did a great job of talking about all the many positives that we're seeing, and they are true and abundant, I do want to hit on some of the challenges that we've faced in making some of these transitions, because they're, I think, instructive to think about when you're launching or developing new technology solutions. So one of our challenges with going to video is that we don't have the infrastructure in the courtroom. And as Justice Hamona said in the initial cameo appearance, don't overlook the hardware. And that is something that we realized right away, because we didn't have webcams on all of our benches. And so we did probably what everybody did, was we got online to buy a bunch of webcams, and guess what? All the high quality ones that we wanted were back ordered for months. And so we were waiting, you know, we had the technology in hand, but we couldn't actually use it. And we had sometimes, you know, people were using their own laptops or their own smartphones or their own iPads. You know, our judges were doing these things, or we were moving them from courtroom to courtroom in some of our locations. But we had a real challenge with having appropriate hardware in place. We also had really old laptops. Some people were joking that some of our equipment needed driver's licenses, that they were so old. And so we again got behind lots of other entities in backlog and waiting for things to come in. Luckily now we have webcams for all of our judicial officers across the state. Now we're waiting for more webcams because we want to have one for every single one of our employees in our 40 courts, because we're doing remote training. We can't do shoulder to shoulder training anymore. So that's been a challenge and a barrier, is to make sure we have appropriate information. Screens, big TV screens. We had TV screens in our courtrooms to display things, but now we need bigger ones, and we need more of them, because when we are doing some in-person things, we're spreading people out to be socially distanced all around the courtroom, including we've done some jury trials, and we have folks spread around the gallery where the public would ordinarily be, and it's harder to see where our screens are located. So there's these infrastructure things that we're rethinking, and the number of pieces of equipment that we need. So that's a challenge. We have had a lot of issues with our Department of Corrections facilities, because like most places across the country, a lot of our jails locked down pretty early in the pandemic and isn't letting anybody in, even to pay bail, no visitors at all, including attorneys to meet with their clients. And so we have Polycom systems that we are ready to put into jails, but they won't let us in to install them, do the wiring, the cabling that we need to do. So that's a barrier we've faced, that we can't get access to some of the spaces we need. In terms of attorney-client communication, within our jails, there is a real issue with not having enough private spaces for attorneys to meet with their clients. So that's creating a backlog for us to be able to move some issues, because attorneys can't meet with their clients in a meaningful way. Recently, our Department of Corrections did install a bunch of laptops with Microsoft Teams, which has really helped to enable that attorney-client communication. But there's some really simple issues that are difficult to solve when you have a pandemic and you have issues where you can't physically get access to spaces. That ends up having a downstream impact on how cases work. We have difficulty scheduling hearings within the prisons, because they're just not set up for that, and they're trying to move people all the time to keep them socially distanced and in different kind of lockdown parts of facilities. So to get access to phones or to video conference isn't easy, even within the facilities. We have some barriers with some of our criminal justice stakeholders don't want to use Zoom. They might want to use Teams. And so there's that, what is the right software? Even though we've gone on Zoom, some of them say, no, we don't want to use it. So, you know, we have to work out some of those issues. One of the challenges we're finding is evidence sharing presentation during Zoom hearings. So when I mentioned we have these large number of screens, sometimes we're spreading folks out in the courtroom with these TV screens. We have security concerns because attorneys want to bring in thumb drives or even DVDs. I didn't even know anyone used those anymore, but to plug in evidence into court laptops, which we don't want them to do. So then we have to worry about getting standalone laptops and just a whole bunch of challenges when things like that come up. So of course, we're looking at evidence sharing platforms that are cloud-based, and we don't have to worry about people bringing possibly infected things into our courtrooms. Public participation in Zoom hearings. So we are streaming to YouTube, but there's challenges with depending on the kinds of proceedings. Like if we're doing something involving jurors, you don't want to show jurors because they can't be seen. Not showing confidential or even grisly, photo evidence and sensitivity to that. Concern always about screen grabs and having people, take that stuff off YouTube, even though we delete the YouTube video at the end of the proceeding, stuff is out there during the time that it is. So there's concerns about that from all of the various stakeholders we engage with. Off-site proceedings. So many of our courtrooms are really not large enough to socially distance our felony trials. We have shut down our trials right now, given our high case numbers, but we have to investigate going off-site for many of our court locations. And then we have challenges with off-site recording capabilities. And so that's just an issue that we're working on. User education is another issue because not everybody is born knowing how to participate in these hearings. And so it takes a lot of time to educate staff, judges, attorneys, litigants. And then one of the challenges, particularly with Zoom, is while it's super intuitive and user-friendly, the different platforms don't have all the same instructions. So if you're accessing from a tablet versus a phone versus a computer, there's different interfaces. And so working through all of those when you're trying to get everybody oriented can be time consuming. And remote work isn't possible for a lot of our staff just because of the nature of their jobs. And we are largely a paper-based system here still. We are transitioning to e-filing, and we've done email filing during the pandemic. But we still need our in-court clerks in our courtrooms to turn on the recording equipment or somebody to do that. And there's other parts of that that make it challenging. So not everything has been entirely snap your fingers and smooth with the move to video. Interpreting is another issue that we experience challenging times with, because while there is simultaneous capabilities for interpreting within Zoom, if you want to record the consecutive interpreting when it needs to happen, the interpreter is in the wrong part of Zoom. So that's something we're working on and Zoom is working on, but that's another challenge. And then one of the most interesting challenges we have faced is, since we've long done successfully phone hearings, is a lot of people just want to stick with that because it's easy and it's comfortable. And a lot of our attorneys don't want to be seen. They literally they want to shut their video off if they're on the phone and just not be seen. And so that is kind of a cultural thing that we need to get over with some of our folks. We're doing grand jury by Zoom in some locations, and we're moving there in more of them because our case numbers are so high. That has largely been really successful. But there is challenges in terms of we loan tablets out because not everybody has devices, not everybody has data plans. And so coordinating that is challenging. We do technology surveys in advance to identify what are the tech needs of the folks involved so that we can match them up. And there's a challenge with managing the evidence because we don't want to put the evidence online. So we have the foreperson in the courtroom, and they manage the evidence and do screen sharing as needed with the evidence when the jurors are deliberating. We've also done presumptive death trials, which are jury trials when somebody goes missing or goes down in a fishing boat. We've done several of those here, and those are similar considerations to the grand jury, but we have the judge managing that process, so that's worked quite well. And then we've done jury selection by Zoom for parts of some criminal and juvenile delinquency trials, and that has worked pretty well. So I'm just going to close with my remarks with saying that courts need to really do their part in making these experiences successful and incorporating technology, because we really need to be flexible, which I think most people are. And we need to simplify our processes to make them fit with the new technology and not just take old cumbersome processes and put them online, because it's likely going to be not very successful. And we also need to use this time to really try things and create rules that make sense for the new ways and the new technology, and not try to kind of bend the technology to awkwardly fit within our existing rules. And I'm super heartened to see this is occurring all over the country, and it's really the time to experiment. So I welcome the challenges, and I hope that all of those involved embrace these challenges, because I think they're only going to lead to better practices once we get through this really challenging and scary time of the pandemic.
I appreciate those comments, Stacy. You brought a lot of considerations to the table in terms of, right, it is wonderful that this technology has come to bear, and also there are still challenges that need to be overcome. And so hopefully our industry participants out there are listening and able to opine on that here as we get to that section of our day. Judge Hale, yes, I'm sure that you are also struggling with some of the things that Stacy has brought up. And so what's your perspective on some of that, and how are you seeing things at the local level?
Well, I think my name is Butch Hale. I'm the district judge in Sherwood. We're a limited jurisdiction court. We handle criminal, traffic, civil, small claims cases, not jury trials at this level. That's the circuit court level. But yeah, I think Stacy enunciated clearly a lot of the issues that we see, I guess, not only in Alaska, but also here in Arkansas. We were fortunate enough back in 2017, I had gone to an e-court conference, and they had talked about making courts user-friendly more to people and trying to keep people out of courts. And so we really kind of started adapting technology more toward that particular focus. As a matter of fact, Chief McCormick, we're using Court Innovations Matterhorn for alternative dispute resolution, which is a company out of Michigan. It's very successful, it's wonderful, gives people a chance to challenge their traffic citations out of court online without actually hiring a babysitter and missing work. But I think Stacy did such a good job enunciating the same issues that we struggle with as well, insofar as adapting from Skype, I guess the Polycon to then Skype and then now Zoom. And so I'm interested in hearing what the other panel has to say about it.
I think you're muted, Sue.
Thank you. I'm learning technology myself. So Robert Adelardi is a chief technologist, and having to bring all of these kinds of the hardware, the software, and all the parts and pieces together to make it all work. We'll throw it over to you to give us some of.
Thank you very much. So yes, I was tasked with just make it happen. It was a simple task. So in general terms, like everyone else, and I'm going to probably repeat some of the experiences from my fellow panelists, but yes, we had to literally pivot on a dime. It was from yes, we did have e-filing, but we also, like had been mentioned also, we do have a large self-represented litigant population in, for example, in our family division, 80% of all of our cases has at least one party that's self-represented. So access to justice, yes, technology is available. Now, how do we make it available for everyone? Not only that, but it was also that the internal training. We had, for many years, we probably pioneered in the nation the concept of having video conference between the jail and the courthouse, so we didn't have to move. First appearance and bond hearings were done that way. But for the soundings for every other type of case, usually the inmates were transported. Well, that was shut down fairly quickly, and we had to set up together with our partners at Miami-Dade Corrections and state attorney and public defender, we had to set up a method where justice can continue. The hearings had to be, had to happen. There was no way of moving inmates around. Everyone that was in custody, we had to look for ways of getting that done. Eventually, we had to move that for pleas. How are we going to deal with pleas? We had to do the out of custody. We still had to provide technology and the safe interactions where people could appear remotely. What we did was we had the judge sitting in his or her house or his or her courtroom, but the person that was appearing before the judge would be in a certain area in the courtroom that was on the first floor. No need to move them within the building, in and out quickly. If they accepted the plea, then they had to be fingerprinted and so forth. So that was a challenge in itself. It's not only the technology, but even the low-tech PPE type of equipment that is needed. Now, as a joke, we started talking about BP and AP, which is before pandemic and after pandemic. Now everything is, when did that happen? When would we try this? When, you know, and it became a running joke. But the reality is there's a lot of technology that throughout the years we've purchased that is no longer feasible. There's a simpler, less expensive, quicker way of doing it. A lot of mention in this conference about polycoms. Well, all of a sudden, what can I do with a polycom that I can't do with a Zoom license? You know, and it's the hard codec and hardware-based system versus just having a laptop or a PC with a webcam and so forth. So that discussion happened fairly early in the early days of March. We were going crazy trying to find webcams. We were going crazy trying to get headsets, even external speakers, whatever we can get our hands on and at whatever cost, we were going crazy. Some of our justice partners had surplus equipment. They were able to lend with the permanent distinction. They were able to lend some equipment to us. So all of that had to do, you know, again, early days. It got to the point where basically, because of everything that we were seeing about a month in, I was joking with someone up in Oscar with the Office of State Court Administrator, and I said, you know what, this pandemic has done more for modernizing the courts than any AO that your Chief Justice could have written up. So, you know, we're going back. We were forced upon this. And the interesting thing is, we have judges, low-tech judges, people that needed a lot of handholding. They are loving it. I'm sorry to say that a lot of judges don't even want to come back to work. They want to continue to business as usual, and it's above my pay grade. Let them duke it out eventually. I don't know what's going to happen, but people don't want to come back to the buildings. We're, you know, kind of still on lockdown phase 2, which means limited traffic in the courthouses. We're not doing any jury trials yet. We're figuring out if we're going to do in-person jury with social distancing, if we're going to do jury trials via Zoom. All of that is being weighed, the pros and cons. But again, early on, there was a lot that the IT portion of the organization had to work with, and a lot of it had to do with training in-house and making training available to our users. In-house, we had to get our judges, general magistrates, all the personnel that needed access to Zoom, they had to get trained. They had to. There was a shift on how we handled evidence. There was a shift on we even integrated within our judicial viewer, our judicial bench viewer. We integrated Zoom with the APIs, and we're able to create the scheduling portion. So whenever a hearing was scheduled, you already have with the API, you already have the Zoom session scheduled. You get all the parties get notified by email. We were able to, again, pivot very quickly, and given that we have the resources as opposed to some of the other court jurisdictions that are probably, you know, limited in the IT department, we were able to innovate. We were able to bring in all these changes. On top of that, and I know it was mentioned earlier in I think Alaska, we also had partnered with Matterhorn for ODR in a specific pilot that we were working on here in Florida. We had selected a specific transaction, which was the traffic compliance cases. Now, all of a sudden, we went live during the pandemic, and the hearings were already, we had pivoted to online hearings. So we were saying, if will people use it? Will people use this ODR experience if, anyways, they don't have to come to court? And the interesting part was everyone wanted to use it because the ODR brought them the advantage of it's not even being able to appear remotely. I can do it whenever I want and not at the time and date that my court is scheduled, my court date is scheduled. So, we went from even integrating new processes that had been not looked favorable upon because there was people that were not happy that we wanted to do a pilot regarding ODR, but it happened. What else? I would say in general terms, one of the things that helped us most and was a game changer was we started having daily Q&A sessions, 4 o'clock in the afternoon. Everyone that had an issue with Zoom, anyone that had a question, anyone that had even integrating the systems with their new way of conducting business, we would have a session every day. And we had those sessions, we had 100 people, we had 150 people. And the most interesting thing was they were answering themselves. We were like hosting it, but we had judges answering questions that judges had and JAs answering questions that JA had. And we created the concept of the tech guru. So in our SharePoint that we propped up for the everything that was related to training during the pandemic, there were points of contact within different buildings that could answer and different case types that can answer very specific questions. We had judges as tech gurus. They took it upon themselves to be that go-to person if another peer judge had a question. All of that was happening, and I would say probably within less than 2 months' time, all the infrastructure was up and running. We were conducting, 2 weeks in, we were already conducting remote hearings. Adoptions were happening. I was very surprised that not that the technology was available and that, but the way it was adopted by our users. And like I said earlier, people that would in other moments shy away from technology, our more low tech judges and users, were all of a sudden they were the ones that are coming back with during these Q&A sessions. They would come back and say, you know what, I'm doing this way and handling cases with the breakout rooms and Zoom and moving people around. And this was a judge that I was lucky if she could reset her password in the past. And now, these people were innovating and explaining and telling other judges how to conduct business, which was very interesting. There was, yes, a lot of sessions regarding hearing etiquette. We had the good old stories of the attorney appearing, lying down in bed and on a t-shirt and wanting to hold court, be present as an attorney in their boat, fishing in the middle of a lake. These were the things that also a lot of external trainings had to happen. We had to set up some basic rules so that everyone was on the level playing field. And now we're which is something that has been talked about a lot. Well, now we're toying on how can we put kiosks around our city so that people can actually use the Zoom hearings, because we assume that everyone has a smartphone. We assume that everyone has the technology available to participate from a Zoom hearing. Well, that's not the reality. We do have a basic percentage of the population that doesn't have that access, and they're not being served by the court if they need to be served by the court. And once again, I think to wrap it up, it was for us in the technology field, I loved it because all of a sudden we got to use all the toys. And with that, I wrap up my participation.
Thank you. Thank you for that. You guys have done some very interesting things, and I'm sure You're seeing that across the state of Florida as well. Heather Pettit, we're going to bring you into this conversation to kind of talk to us about where these courts can find some of the funding for these initiatives, right? We've heard a lot about the kinds of challenges, the hardware, the software sides, the organizational sides. Perhaps you can help us out with understanding what you're seeing in terms of best methodologies for funding.
Absolutely. Well, one of the things I do want to circle back, and I'll touch on funding. There's two kind of areas of funding that I'll call out, but there was the conversation of multiple platforms and how do you engage with multiple platforms. I have to say, here in California, we use probably 4 or 5 different platforms. And one of the ways that we are addressing that is not by mandating or dictating, however, many of the bar associations would like us to, but instead putting together best practice guides and allowing then the courts to apply their technology solution to those best practices. And that seems to be very effective. We share that. We have a really great community here in California. So that's some of the things that we've done that to help be successful. So that is one way you might be able to address that. You know, this is where you're going. I want to do X, but it's only available in Y. Here's a way to address that. So that's one of the things that we've done that could help is in a marketing technique. And we've tried to really market that as much as we can across the state. But when it comes to funding, so there's 2 really specific areas that, you know, we have looked at in particular. One of the things about the pandemic is that, you know, California was already in the place of moving to this concept we call the virtual court or the virtual courthouse. And so for us, we had already done significant work on remote video, VRI, you know, just a lot of the analysis. But part of that really key piece of it was understanding the rules that surround it. And so right now, most of us are all operating in emergency orders because of the pandemic. However, think about it like this. When this pandemic is over with, we've now created these amazing services for people. How do we continue to provide them? Right. And so people are happy staying at home. People are enjoying. We have now actually seen something that us technologists have known for years, that you can work remotely. Right. I mean, that's one of the things that's a very different concept. And so people who never believed that government employees could work remotely are now seeing that they can. The state of California is mandating that anybody who can work remotely, 80% of the staff should be working remotely, purely from a perspective of saving buildings, looking at offloading, you know, unnecessary real estate, right? I mean, it's just, it's a different mindset. I think we're moving more towards the practical reality of work versus what we've always thought work should be. So when you're looking at this, though, is that you're looking at the rules that govern these types of technologies. So when you're talking about remote appearances, many of us are living in the world where statutes exist where it says phone conversations or you must be in person. So addressing those types of limitations in advance actually allows you a lot more flexibility for forward funding or planning in advance where you want to go. So in California, we do have rules around, you know, the cost to do a telephone appearance, you know, looking at the rules and making them technology agnostic, you know, not specifying phone or video, looking at a piece of technology for a remote appearance that you then can, you know, put a, you know, reasonable fee, a cost recovery fee associated with that. And then you can fund the program as it is. So LA is a perfect example of a court who, you know, they charge a small fee for their remote appearances, but it has funded basically outfitting every single one of their courtrooms with brand new remote appearance technology, which is phenomenal, which means it's not only just in criminal, but it's across all of their courtrooms that they are working this out. That was the only way that they could have been able to do this during the pandemic. They started in April and they just pushed this technology out. So they've been furiously putting all this technology out there. So they are ready to go as we continue to progress forward with this. So that's one way to look at this, is taking a look at your current rules, seeing how they apply, seeing where you're allowed to do, make, you know, cost recovery initiatives, because we're not profiteers. We are here to service the public, and we want to do it for reasonable costs, right? We want to be able to provide these services. Now, once these are paid off, it could be minimal, you can reduce it. So that is one way to look at it. And that's how the ways we do it. Especially though, as I say, ongoing, future funding, keeping this technology going forward once this world changes. Because if you're not accounting for that, in our legislative cycle, it's a 1.5 to 2 year cycle to get rules changed. So if we are not thinking about that today, when this pandemic ends, what happens when all our emergency rules go away? We're gonna discontinue these services. I'm pretty for sure attorneys don't want to do that. I'm pretty for sure, as we heard earlier, judges love being able to do remote hearings. People don't want to have to come into the courthouse because of all the other various life issues. So why not provide that Amazon service right up front? So I think that that's a do it today in planning for the future kind of model for funding. And then of course, the second model for funding, of course, is advocacy. That when you look at the world today, every single legislature out there is scrambling to address issues with the pandemic, whether it's the unemployment, it's housing, it doesn't matter. But we, in the end, are the last vestige of, if you're going to get kicked out of your house, you come to court. If you need to pay your mortgage, you come to court. So how do we continue to provide justice for these people when we don't even have a means for them to come to court, or it's not safe for them to come to court? And so in that space, the timing is ripe to be able to use the data we have learned over the last 6 months with putting together these remote appearances to advocate on behalf of the branch to the legislature. And that's one of the things that we have really spent a lot of time and energy on doing that. California just received this year a modernization monies. It was $25 million for modernization, of which we can see the number one priority that the courts are spending on this, and is specifically for the trial courts and for this year, is remote video technology. And the other piece of it is not just remote appearances, it's remote public access. Because what's thing about it is that you can have court going on and people can be appearing, but if you can't hear what's going on and your grandson or your uncle or aunt are in a courtroom and you don't have access to that, now we're limiting their rights. And so that other piece is their ability to listen to the listen to the technology, listen to the court hearings that are happening, because unless your courtroom is the size of, like, I don't know, a basketball court, and you've got lots of room where you can have everybody who wants to come in and the media and everybody else, it is extremely difficult. So that's one of the things that we're struggling with, because we are doing jury trials here in California. So we're renting, lots of auditoriums, high schools, civic centers, to be able to do juries and bring them in line and be able to do this. So when it comes to this, you now have all this data that you can go and take and provide to your legislature and say, hey, this is the perfect timing for us to put funding, whether you have a budget change process, whatever your mechanism is to get this done, partnering also with a lot of the bar agency, self-help. Any of those groups right now are also hungry for this technology. For us right now, we know that the civil bar is really concerned because while we're doing jury trials for criminal, most of the courts have not started civil trials with jury. And that's a big deal because there's a lot of people who need that process to occur. And so for us, it's an opportunity for us to advocate on going through the legislation to get explicit funding for these types of things, because the time is now. They're all getting hit by this information. They all know it's a big deal. We need to be successful in order for them to be successful. It's a great time for advocacy right now. So those are the two areas that we have found that have been really, so far, fairly successful in looking how to continue to push this technology. One kind of last thing to thinking about this is that, as I mentioned, forward thinking about this is that we will get to a place, if we continue on the path we are and we continue to do remote hearings, let's say through the summertime when the vaccine is widely available and then people are starting to come back to work. We're at a place where people are going to be so comfortable in this space that it will be like, don't take away my Amazon. Don't take away my ability to do something very efficiently and effectively. Yes, there are those people who like to come in person, but even those people who traditionally are afraid of change, want this change because it becomes easy for them. Whether it's Zoom, whether it's Teams, whether it's Blue Jeans, it doesn't really matter because it's comfortable. It makes sense, and it takes their valuable time and makes it even more precious, and they can use it on the things that they want to spend it on. So think about today how you get ongoing funding to keep this going forward, because truly it is the world of the virtual courthouse. It's where we're going in the future, whether it's electronic filing, digital evidence, it doesn't matter, because in the end, it's all going to come in some sort of virtual way. And this is, pandemic this year, pandemic 5 years from now, we better be even more prepared. And it should be a flip of a switch that we can start up and get going on the next major event or catastrophic hurricane, fire, flood. I mean, we have all those in California right now. So, so I just think that it's in the point that these are the ways. And so advocacy, looking at your rules, cost recovery mechanisms, those are really the ways to look and getting it done.
I appreciate that. I think you bring up a huge point with respect to, let's use data right, as the evidence that we need. We use it all through the justice system. This is also a, primary spot for being able to justify the need for continuing these kinds of operations, because I think that's a super important point, that at some point, this just needs to be what we do. With that, I appreciate all of the panelists and all of you weighing in here. I'm going to ask Joe if we have any questions that have queued up in our from our audience.
So a couple of things. One is Kevin put a question out to the technologists that are out there in the audience. And I want you to noodle on that as we hit on some other questions. And one of the questions that we got from our last session, and Heather, you talked about jury and all that. There was a question about jury proceedings and the needs to keep those confidential. And this is to any of the panelists. What are the needs to keep those, to support those proceedings virtually, keep them confidential, and what solutions do you lack in that space that industry might be able to help out with?
If I can add, definitely the confidentiality is paramount. One of the things that have been coming up every time we have this discussion about jury trials is if you're streaming this hearing, this trial, or even the jury selection process, is traditionally there was a agreement with the press. If the press would come in with cameras in the courtroom, the faces of the jurors would not be shown. There would be angles where you cannot see the juror. Now, interestingly, we were looking at, is this just a practice, or is this a rule? Is this, where does it say that we shouldn't be showing the faces of the jurors? And interestingly, it wound up being, it was just an agreement between the press, the courts, and the parties. So we were going back and forth of if we're going to do this setup where we're going to be showing what's going on in the courtroom, we have to angle the cameras so to guarantee a little bit that confidentiality that they do have usually. And I get it. If I am in the in the pre-pandemic era, before pandemic, I could walk into a courtroom if it was an open hearing. I can walk in and I'll see the faces of the jurors, but it's one person, 30 people, 20 people walking into the gallery and having access to that versus streaming that, potentially getting that screen grabs and so forth. So you always have to look at both sides. So yes, there is a need to be able to, for technology to be there where you can say on the fly, not as a post-production, but on the fly say, this area, do not show it, or these people should be, just select and say pixelated, or I think there is a need and there is a space for an easier management of that, of being able to provide that confidentiality.
So if I may, one of the things that we have several of our courts testing is online voir dire process, which has really been quite remarkable. So what they will do is the traditional voir dire questionnaires that come out, they will fill them out, the juror pool will fill them out electronically, and then they will do selection based upon that and then do a direct call to a group of people, and then they will go through and segment them out. So if you were, let's say you have like I said, many of the courts have run out like civic centers or school gymnasiums where you would, do voir dire. This is your group of candidates that everybody agrees upon, and a just brush of here's your first pool. They get called in at the number that they're allowed to. They will go through that process with the judge and the attorneys in a large setting. And then as the panels get more and more, then they would report directly to the courtroom. So that's something that a lot of the courts have been testing. It's very difficult to get beyond the face-to-face need to interact with jurors. We have not yet tried an online kind of jury or remote jury selection process. I think that it's something that makes little people uncomfortable. One thing I think that is a little different in California is that, our juror forms are not confidential. They're actually public accessible to any of them. There are key elements of them that are, but if you're in the courtroom, you're in the courtroom, it's public information. So that is just kind of how we address it. But I do think that the concept of online selection based upon data is a really key point, because it gets you to a pool that automatically may eliminate you to 50% of what you would need to bring somebody in, right? And so I think that right there makes, because if you think about it, half the time when they're over there discussing and negotiating between the DA and the defense attorney, they're just looking at the sheets of paper. They're not seeing the person's face, and they're like, oh, I don't want this person. I don't want, yes, yes, yes. And so if they can do that in advance electronically between them looking at this, that gives you an opportunity just to bring in the people that you really need. So I think that would be a good value. I know there's systems out there that do that, but I think that that's a great opportunity for courts to look at. And I think that now in today's world, judges may be more inclined to look at something like that along with their partners in the courtroom.
So Heather, really, the virtual aspect and the video aspect is one aspect, but there's a whole process aspect that's fundamentally different that also goes along with it.
Yes, for sure.
Well,
go ahead.
I was going to say, other panelists have anything to weigh in on this?
Yeah, we everything Heather said in terms of voir dire is absolutely right, because our goal is, when we're bringing in jurors, is to be the most efficient possible and to bring in the fewest number. Really, the ideal is to do, in my view, is to do virtual selection. And then, we haven't got a high comfort level to do a criminal trial virtually entirely. I'd love to, but I can't get agreement by all the players at this time. But virtual selection, so you're only bringing in those you need. And we're doing online questionnaires in advance to cull down the group that will automatically never need to be coming in, including hardship requests, for those who are at high risk to be getting severe illness because of underlying conditions, your childcare issues, all the things, married to a police officer, whatever those issues may be, so that those people never have to come to the courthouse because they would have been excluded anyway. So those are things like in my jurisdiction, we actually fly jurors into some of our courts because they can't get to the court, which is hugely expensive, which when we go back to real life, that is after pandemic, we are never gonna do like fly-in jurors to do paper questionnaires at the courthouse ever again. We're gonna do online questionnaires. So some of these changes are just smart for jury utilization. And in terms of an administrator perspective, and I'm sure judges share it, most normal people only come in contact with the court through jury service. And if you want to instill public trust and confidence in our operations, you have to use their time wisely. And if we waste their time by calling 5 times as many jurors as ever going to be seated, they're going to probably walk away feeling kind of irritated. And so the more we can change these practices now so that in the future we have better practices, this is the time to experiment.
Very cool. So Kevin threw a question out there, and Heather suggested that there may be some models for helping out. Were you responding to Kevin's question?
Yes. So, there's a couple different, so we've seen this actually a lot, especially in the high volume in the big courts. One of the things that we've had to move to a model of, which is absolutely crazy, which I never thought we would do online chat for technical support for folks who are having problems. LA is using this model, as a matter of fact. They've actually had a staff for anybody where they're having audio sound issues. They actually, as part of their process, when you get logged in and you get into your courtroom, if you're running any problems, there is an actual online chat person now who can support you on your technical support issues you are having, getting to the courtroom, getting through the court processing. It's expensive. We couldn't believe it. We were shocked. We made fun of Snorri for it because we just thought it was not necessary. But the reality is that because they have thousands of people who are calling in to their courtrooms and going through this process, they had no choice. So that's one model. Another model is that we actually have staff who have they're assigned to a courtroom to help people on board in advance. So if you're coming and you're an attorney and you're running into sound problems, you've got a technician who's assigned to that courtroom who will help you make sure that they're paying attention to multiple sessions. So it's similar to the online chat, but it's more of a person-to-person chat. So really, that's what we have found. I'm actually curious if Robert has found anything in their area, because that's the best way that we have been able to get through technology challenges to get to keeping the trial going efficiently and as quickly as you possibly can.
So yes, Heather, interesting. We've done a couple of mock trials, pilots, tests, whatever you want to call them. And yes, we had to have someone that would take them to the breakout room. Let's sort it out. Let's get you renamed. Let's deal with your audio. And it was a lot of hand-holding, and but yeah.
So, one of the questions that we had coming up here was how this is procured. Now, through the pandemic, I mean, Chief Justice, you'd mentioned that you had some licenses previously, and then you bought some more licenses, and you cobbled things together for virtual hearings. The delivered product is the virtual hearings and a set of services, and it might be integrated into jury management system, or heck, integrated into some way to case management or scheduling, as Bob Rath pointed out. Do you see procurement for these virtual hearing services post-pandemic, going into the classic RFP approach, or is it a commodity buy where you guys cobble it together? How do you see acquiring these services, these technologies in the future?
I mean, people probably are going to have different answers depending on the way their court system is organized. Michigan is a non-unified court system, and one of the ways we organize is by the State Court Administrative Office offering good products to the courts throughout the state. So buying the Zoom licenses 1.5 years before there was a pandemic was just one of many examples of things we try to do to promote uniformity throughout the state. But so how will we think about it going forward? It's a great question. I mean, a lot of those services, we do think about them that way. This particular emergency has caused us all to just, kind of do everything. We're building the plane in flight, right? So we haven't stopped and thought about what that'll look like going forward. But I don't know. Somebody smarter than me is going to have to advise me on that. It's a good question.
I mean, Heather, in California, you've put together master agreements for things that California originally did themselves, like e-filing. They had 2 Jeffs that they put together, and now you folks have a master agreement in place for things like that.
Yeah, so we actually are about to release an RFP for master service agreements for remote video solutions, as a matter of fact. We did one previously for VRI. Actually, I have the requirements. It's with our attorneys right now. And it was more technology specific. So this one is a little bit more technology agnostic and based upon use cases. It also includes a component for digital evidence, as well as some of the other kind of digital courtrooms and integration pieces. So our goal is to have probably 2 to 3 vendors that courts can select from that all integrate into our digital ecosystem, which some of you guys may know as CourtStack. And so we are designing that right now, which then hooks into all of our case management system vendors. But yeah, that's going to be coming out in the next month or two. So we will have broad scale agreements. Now, that being said, we also leverage agreements from the state. The state has Microsoft licenses, BlueJeans licenses, Zoom licenses, as well as, so we do leverage those agreements, but they're individual kind of, we wanted something that meets our court's business use cases and needs. I mean, we're working with all of these vendors directly. So Microsoft, Zoom, BlueJeans, even Cisco with WebEx on requirements for this virtual courtroom or courthouse environment, digital staff, virtual staff, all of those types of things. So they have these list of requirements. And I will say, quite honestly, after meeting with all of them over the last several months, by the first quarter of next year, they're all very competitive. From the hardware to all of the feature sets, I would say they're pretty much going to be one and the same. It's just going to be your choice of what you want and your choice of security versus hardware. But for us, it's about the integration. And so, in the end, it doesn't matter as long as it integrates appropriately and has the right security requirements. So we will be doing an RFP for more streamlined procurement, because it does take a while for us to do procurement activities.
Right. So we've heard from California, which is huge. And Judge Hale, I imagine that your court's probably not operating at that kind of scale.
No.
Are you looking for that kind of a procurement solution or something else?
Probably something a lot smaller scale. Right now, I think we've got in place that which we need, Zoom and the ability to have Zoom hearings. And so we still operate kind of open, because today we had our trial docket or arraignment docket, and we still were able to move people through the actual court. So we've not gone fully Zoom as of yet, although with our numbers going as high as they are, it looks like we're probably going to.
Now, Ryan brings up a question about video and audio files. And Ryan, I don't know, do you want to just share that with everybody there? Or can you unmute?
Okay. Hey, obviously everyone's doing a ton of video, a ton of audio. Retention, are those files being stored? What are you doing about that? Have you thought about retention requirements? Do those fall under retention and typical FOIA laws?
Okay, can I chime in here? It's the hot topic of the day in our circuit. Okay, so the first thing is the content is what is relevant. The content will drive the retention periods, not the medium. And we early on, we tried to persuade our judges to not record anything via Zoom. We eventually locked it down, because the problem is there is one official record, and the one official record is the record that's kept by the court reporter in our due process recording systems. The problem with creating multiple records, even though it's not the official record, is they're all eventually discoverable, and they all fall under, in Florida, Sunshine Law. They're all part of public record. So yes, the more people start recording on their own, and they start saving the chat conversations, and they start doing all these things, the more complicated it will get to actually store, file, index, and so forth. So again, we integrated within our courtroom scenario, we integrated Zoom into our digital court reporting platform, so we would not have a lapse of service. Again, the official record is the record that's kept on our due process hearings.
Mhm. Any other insights?
Joe, if I could add one thing to that, we found it kind of interesting. I agree exactly with what Robert was saying, but we had some technical failures on a couple of occasions with our official court recording in our system. And we found that because we had also recorded it on Zoom, we were able to transfer it over and make it part of the official court record, so we didn't lose anything. And then we deleted the Zoom file. So now that has just been something that has been very helpful as a backup, if you will, that was unexpected in our case. And because they're, Robert's point, especially about the chats and other things that can happen online, if that's enabled, you don't want a lot of that extra noise becoming part of the official court record.
Other thoughts from our panelists?
It's the same for us. Our official record that is, we use CourtSmart for our digital recording. We integrate Zoom into that. So that's what matters, is our official court record.
Mm-hmm.
Very good.
I have a question along sort of that line, which is, we're talking about a bunch of different, technologies that are kind of coming together to help obviously manage all of this. Are you finding anything in terms of, at sort of at the hub of that, you've got a case management system. And so my question is really about the needs for that level of integration. If you're finding that to be something that would be helpful, that is all of these different kind of parts and pieces also hooking back up into your CMS to the degree where that is, appropriate and needed. Anybody have experiences with making that happen, or is it a thing that you're looking at?
Well, when you scheduled a Zoom hearing, it got docketed into your case management system, that would be amazing. That is not the case though for us. I would love that.
So we have our judicial bench viewer, which actually reads from our case management system. Given that, everyone's special in Florida and we're not the exception, our clerks are a separate entity from the court. So they run the case management system. We run the judicial bench viewer. So again, we read from there. We have a in-house built system. So we were able to, like I mentioned earlier, very quickly integrate the APIs that Zoom have into our platform, and without having to wait for a vendor to turn around, test, develop all these nice things that can take months. We were able, within less than a month, we were able to integrate within our scheduling tool, integrate the API, and now everything is integrated within. So the judge basically goes through the calendar and just clicks Zoom, 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 and they jump from one hearing to the other without even having to use the Zoom interface. It's just they're looking at their calendar and jumping from one hearing to the other.
Great.
Yeah, Sue, I would agree with Rob. I think having that integration is absolutely mission critical, especially when we're talking about the user experience. Judges, courtroom clerks, we talked about, fatigue in general of efficiency when they're used to running their courtroom. So having that as part of your ecosystem is really, really important. Integrating with the case management system. That's something that is a requirement for us as well. Not all of our courts do it, but it is part of our digital ecosystem, long-term plan for all of these to be integrated with our case management system vendors, just from the scheduling perspective and to be able to, communicate. Yes, CourtStack. It does go back to CourtStack. So, we try to make sure that it is a seamless process. The user experience is always going to be a seamless process, whether it's the public attorney from the judge to the clerk. It needs to have the same type of experience and efficiency as you would being in person. which is very difficult because, you know, using the digital evidence, all of those things. But when we're designing these, to me, you don't want to have to reinvent the wheel. And more importantly, you don't want people to get frustrated with the technology. We want them to be successful with it.
Right. That makes sense. Looks like we are hitting right on our time, everyone. And so anybody have any parting comments before we sign off from today's mini summit? Panelists, thank you so much. We really appreciate you being available to this, and to all the participants as well. On behalf of the IJIS Institute and the IJIS Courts Advisory Committee, if you're not a member of either of those two things, you certainly should Google that and look them up and become members. And just so you know as well, one of the things that we'll be doing with ICAC is we'll release a survey following today's session, just to better understand how this kind of a format worked for people, what we could do to help improve, that exchange of information and dialogue, and looking for additional upcoming topics that you'd like to see us cover as well. So thank you very much, Alex, for kind of producing today's session and being the executive host here. And Joe Wheeler, MTG Management Consultants, thank you for your sponsorship. And thanks to all of you for your participation. We appreciate it.
Take care.
I know.
Bye.